Good morning. We're here in our case 1 CA23, Lorence versus Mayo Clinic. Each side will have 20 minutes to present an argument. Appellant, you may save as much time for rebuttal as you want, but you'll have to keep track of your own time. We have a clock at the podium for that purpose. We are recording the argument both in audio and video. When it's your turn, please identify yourself and your client before you speak so that when we review the video or the audio, we can keep everybody straight. The video will be on YouTube in a couple of days, so you can watch that at your leisure. We've read the briefs, we've conferenced the case, we understand the facts and issues, and so when you begin your argument, launch right into what you want to talk with us about. Counsel, you may begin.
Good morning. My name is David Marhofer, and I'm the attorney for the appellant, who was the petitioner or plaintiff below, Julia Lorence. We're here on a decision that was rendered by the Superior Court to dismiss a case at the initial pleading stage. The standards of notice pleading have been observed. The complaint that was filed in the case more than met the minimal standards of notice pleading here in Arizona. And
is notice what we're really talking about, though, or is it stating a claim, or properly stating a claim for relief?
Well, to the extent that I understand Your Honor's question, the complaint asserted a number of claims, and as a whole, the complaint was 25 pages long and asserted plenty of facts that were not conclusory, were not just listing the elements of torts and claims. So there is plenty of an opportunity in the facts that were presented to support the causes of action that were asserted.
Let me ask you about one of those causes of action. What's the basis for your claim for declaratory relief?
The claim for declaratory relief, as against the Arizona Board of Regents, would be to declare the plaintiff's rights in a recommendation that was drafted, written, but not released. It's also to determine the
I need to clarify something there. You said this is the claim against the Board of Regents, but as I understand it, the letter that you're referencing was Dr. Swanson's drafted letter, and it was drafted in her capacity as an employee of the Mayo Clinic, or am I misunderstanding that?
Your Honor, Dr. Swanson was both the head of the department over at Mayo and also a professor at ASU, so she had a joint responsibility.
Okay.
But to go back to your question, and the third one, as was stated in the complaint, was to find a way to assess the damage to my client's reputation and her continuing relations with ASU, which is her alma mater, and the fact that she has been essentially at ASU and at Barrett erased from institutional memory.
But is there a complaint? Is there some kind of instrument that you're seeking to have interpreted for the declaratory relief?
there is no necessarily a complaint or an instrument, although later on there would be an assessment of what rights my client had also in the National Institute of Health grant that she received while and that she applied for and that she received.
So you're seeking a declaration of her rights and interest in the NIH grant,
Among other things, yes.
but the NIH is not a party.
NIH is not a party, that's correct.
Okay. Is there any other document besides the terms of the NIH grant that you're seeking to have construed or the rights and interest declared?
Not as a specific document, but the declaratory action isn't only for declaring rights and duties as far as a document or instrument is concerned. It's more, declaratory judgment is more open-ended than that.
In clarifying some of your claims, I also wanted to just pick a little bit at the letter recommendation. Is the complaint at paragraph 171 describes the conduct of withholding the letter, and then you again reference the letter in both the injunctive relief claim and the Declaratory Judgment Act claim. Are those the only bases for which you are arguing this particular fact? In other words, you describe it as a retaliatory conduct that you are ask the trial court and asking us to enjoin the defendants from retaliation by virtue of withholding this letter. Is there any other basis for which you are asserting the letter of recommendation as an adverse employment act or as a claim for relief?
Well, indeed, the withholding of the recommendation letter is stopping my client from getting into medical school and potentially further on in any career that she would have, because that's an important function that she played at that employment that would otherwise be a blank in her employment history. But the retaliation goes far beyond that, as the court can see from a pretty extensive complaint.
You did not bring a retaliation claim, though, did you? Your client did not bring?
Well, it's a discrimination complaint, and it puts together a lot of the facts that the Superior Court and this court can examine, and the fact that the Superior Court dismissed the complaint in its entirety and did not even give an opportunity to amend.
But you did not request an opportunity to amend, did you?
I did not request an opportunity to amend by Rule 15 prior to the motion to dismiss or after the motion to dismiss was filed, and I did not request one at the oral argument, but the standard for amending complaints that for claims are not fatally flawed is baked right into the legal standard for motions to dismiss. So it's not.
Do you have some authority you could help us with, a case or something that is an example of a Superior Court sua sponte offering to a plaintiff the opportunity to amend a complaint?
Well, those were the cases that were listed in the both in the opening brief and in the reply. And if I may have a quick look, it was In Ray Cassidy's estate, that's a Supreme Court from 1954. There's the state X-Rel Corbin v. Pickrell from 1983. There's Sunworld v. Penny Saver from 1981, and Acker v. CSO Trevira in 1997. And all of those cases say that the plaintiffs have a right to amend, and it's baked right into the standard.
Well, because doesn't that presume that the plaintiffs have asked to amend? I'm not aware of it. I take your point about what the standard is, but I'm not aware of any case that says that a court on its own motion must offer the right to amend if the plaintiff doesn't ask for it.
Well, I understand where Your Honor is coming from, but this is something that is baked right into the motion to dismiss standard, that if someone has claims that are not fatal, then the court should either dismiss them without prejudice or dismiss them and give right to amend within 20 days, which is the standard, and not only that, but if the court had indicated at the oral argument that it thought that there were certain causes of action that were not viable and all that, the court could have said, well, Mr. Marhofer, I don't think that this is exactly right, and I'm inclined to dismiss this. But and if the judge had done so, I would have asked the judge at the oral argument, then, Your Honor, I'll request the opportunity to amend. So it's again, it's not something that is entirely ruled by Rule 15, which is not, obviously, Rule 15 is not automatic, and it regards amendments when the party itself wants to amend versus when the Superior Court says, well, I'll dismiss it because I don't think it's viable and give you an opportunity to amend.
I'm sorry, go ahead.
I wanted to talk to you for a minute about your blacklisting claim. Is there a point in the complaint where you've identified an agreement between two employers, and could you point me to that?
Your Honor, there is no particular part in the complaint that identifies an agreement between employers, and it's not, a complaint, and as all practitioners know, is not perfect. And
let me, just because our time is running, let's say that I'm going to infer the existence of an agreement based on the allegation that you've raised. Could you help me with what is the time period for which this blacklisting allegation, is it an ongoing? Is this specific to, as I understand the chronology, your client applied for 2 additional Mayo Clinic positions in the months following her departure. Is the blacklisting claim specific to those applications, or are there other applications?
Your Honor, if I may, she actually applied for those positions before she left.
Okay.
And that's number one. But the blacklisting is actually a continuous issue that continues on essentially to this day. How
do we know that if we don't have any allegations about subsequent applications for employment?
I think that the complaint itself lists there that she has tried, and she is trying to obtain other positions, but the withholding of her recommendation and everything is stopping her. So again, the lack of a fact or 2 or 3 in a complaint does not invalidate the entire complaint, and it doesn't make it conclusory. The Supreme Court said complaints that are only conclusory are not satisfying the requirements of Rule 8, and that the judge actually, Your Honor, you are leading me to another point that is the continuing torts doctrine. This court
Before
has...
we move on to that, let me ask you
Yes,
about
Your
your
Honor.
ACRA claim, which you allege violation, sex discrimination, discrimination on basis of national origin. What factual allegations in your complaint support your ACRA claim?
I would say that within the 25 pages of the complaint, there are a number of factual allegations for the violation of ACRA. And, again, the complaint is pretty sizable, so there are a lot of facts listed there, and the specific paragraphs do not come to mind at the second, but as a whole, the entire complaint has sufficient facts for all of the causes of action.
But just in general, what did they do to discriminate against her on basis of sex or on the basis of national origin?
Okay, on the basis of national origin, there are again, all of those are intertwined because we have one person who is all of them. She is female, she is of different national origin, she is handicapped because of her stroke. All of those things are intertwined, but from the very beginning of her coming to that position, of retaliating against her for participating in that inquiry by ASU, going on to being prevented from presenting her part of research, continues to her being passed over or not given performance reviews, and others have continued on all the way to the end, to her being accused of a theft of a laptop, which she didn't do. I mean, the continuing nature of all of these things build on top of each other by the same people who have known each other for the previous 5 years, and their motives. You can't possibly have an artificial dividing line of October 4th, 2020, saying everything before that could be, but everything after that, as the Superior Court found, was not discriminatory and was actually value-free.
I'd like to ask you about the letter. What is the importance of the letter? Is it the letter of recommendation itself, regardless of the content, or does there have to be particular content in the letter to make it useful to your client? And if so, how would the court enforce that?
Your Honor, that's a good question. The letter itself was already drafted. Its content is already known to my client because she participated, and several people participated in the initial drafting of that letter of recommendation. We want, or my client wants, the release of the letter of recommendation as it was completed.
Can you see there might be, getting to Judge Howe's point about the content, an employer might change their mind about their evaluation of an employee over time, given conduct or given interactions. And if the claim is this letter as drafted at point A in time, I would like issued at point C in time, disregarding all of the things that happened at point B that may have changed the employer's view. Can you speak to that concern?
Your Honor, I'd love to. I just noticed I have 2 minutes and 20 seconds. I'd like to leave something back for rebuttal. But yes, an employer can obviously draft a letter later on in time, but the expectation was that the letter that was previously drafted, that was enthusiastic and all that, would be the one that would be released because it covered the period of time that my client was working over there, and provides the substantial body of her work. If the employer were to go and say, well, based on what happened just recently, I'm just going to not grant you the letter of recommendation that I was going to grant you before that, that kind of upsets the expectations of both parties that the letter of recommendation would be positive and help open the doors to a future job and position in a medical school.
So once all those are written, you're stuck with it then?
To some extent, yes. If you have a recommendation that is positive and is based on the body of work that you had beforehand and all that, and the change in a letter of recommendation from something eminently positive to neutral or negative would be a retaliation.
And since we asked you questions, we'll give you time for...
Yes. Your Honor, I have 30 seconds, so I think I'm going to make my departure.
We'll add time.
Thank you.
Counsel?
To both sides, right?
Yes. If we'll add, we'll make the rebuttal 2 minutes, and if you need 22 minutes, you're welcome to that.
Perfect, thank you. Good morning, may it please the court. My name is Kylie Tenbrook, and I am Associate General Counsel for ASU, and I am here on behalf of ASU and the Arizona Board of Regents, and I will just refer to them both as ABOR while speaking. ABOR has an unusual role in this case, primarily because it concerns a dispute over employment issues between Mayo Clinic Arizona and the plaintiff. Plaintiff seeks only equitable relief against ABOR in the form of an injunction and declaratory relief. With respect to a request for injunctive relief, plaintiff seeks the court to require ABOR to develop new policies or enforce existing policies respecting retaliation against third-party non-employee witnesses to investigations. Plaintiff also seeks an injunction ordering ASU to require her inclusion on a website for a student organization, that she be invited to partake in events at ASU and mentor others, and that ASU require faculty members to provide letters of recommendation. With a request for declaratory relief, as we discussed a few minutes ago, she's seeking a letter of recommendation from Dr. Swanson, and she is also seeking an acknowledgement in an already published article by Dr. Swanson. The Superior Court properly dismissed plaintiff's request for equitable relief. As the panel noted, for both the injunctive relief and the declaratory relief, there's no legal vehicle through which these things can come about. Plaintiff claims that she can allege remedies and, in fact, admits that they're only remedies, and therefore claims that Rule 12b-6 cannot be used to dismiss her complaint because it only alleges remedies. This misses the point. If the complaint doesn't state a claim, then it must be dismissed. I want to talk a minute about the difference between Rule 12b-6 and Rule 8. As the court had noted, what we're here today talking about is Rule 12b-6. A plaintiff can have all of the well-pleaded allegations in a complaint, and it still may not state a claim, and that's exactly what we have here. If we conflated the two, then Rule 12b-6 would have no purpose. The plaintiff also claims that she should be permitted leave to amend her complaint. As the court noted, it's not up to a court to sua sponte allow amendment, and there were multiple opportunities for plaintiff to request amendment, whether it was the conferral stage, the motion to dismiss stage, or at oral argument. Nonetheless, plaintiff has failed to identify, even through the briefing in this court, any sort of amendment that would fix or cure this defect. And frankly, I can't come up with a claim that would come from those facts, and I believe that such an amendment would be futile. For these reasons, we ask that this court affirm the lower court's decision. I'm happy to answer any questions you all may have. Great.
Thank you.
Thank you.
Good morning, Your Honors. I am John Lomax. I represent the Applee Mayo Clinic. the appellee, Mayo Clinic, Arizona, and all the individuals, including Dr. Swanson, who were named and who are employed by Mayo Clinic, Arizona. I want to answer a few questions that the court brought out in their questioning of the appellant's counsel. Judge Perkins, you're correct. There was no retaliation complaint or claim alleged in the complaint. I also want to note that it was a verified complaint. And it's more than a case in which there are missing facts or two, as counsel suggests. They're missing elements of the claim. And the issue of the absence of the retaliation claim in the complaint is indicative of the fact that a court should not be asked, a trial court should not be asked, sua sponte, and bear the onus of inquiring from counsel whether a complaint needs to be amended. That's placing a burden on our trial courts that's not imposed in the law. And there are actually two cases where this court has spoken to this issue.
Let me interrupt you for a moment. Some courts have recognized a claim for a failure to provide a reference letter. Why doesn't this complaint state a valid claim on that basis?
Attached to what theory, Your Honor, I might ask. I think from a declaratory judgment perspective, it's not a legal instrument. It doesn't have to be necessarily a legal interest.
Perhaps I could hone in on the question a little bit more. I think the complaint clearly ties the letter of recommendation to a retaliatory motive. But the complaint also makes, sort of broad discrimination claims throughout its factual recitation. So, as Judge Kiley points out, there are cases out there that talk about the failure to provide a reference as an adverse employment action. Are we, should we, is it our job in pursuing reasonable inferences to infer that the failure to provide the letter of recommendation here was an act of discrimination as maybe distinct from an act of retaliation in sort of liberally construing the factual recitations here and treating this as an ACRA discrimination component?
Well, I think there are a few leaps in logic in that, Judge Perkins and Judge Kiley. First of all, there's no allegation of differing treatment with respect to the letter of recommendation. I mean, the prima facie case of discrimination is one that emphasizes differences. A difference because of sex, a difference because of national origin, a difference because of a disabled status. So there's no tether to ACRA with a letter of recommendation. In fact, the complaint, I'm fairly certain, discusses the letter of recommendation in the context of declaratory judgment. Judge Perkins, I think you raised a question about whether it was viewed as retaliatory. But I don't see anything in the complaint that suggests that the withholding of the letter of recommendation was the basis for a discrimination claim or an allegation that. I would also add, too, that the cases that I believe the court is thinking of concerns recommendations for employment. I think it's a Pandora's box if you start asking about recommendations to go to graduate, professional school, undergraduate school, or other venues, and whether that in itself is an adverse employment action, because you're not pursuing employment on that letter. You're pursuing admission into a school. And
do the cases that you're familiar with on either letter of recommendation or reference, sort of for just the moment, treating them broadly, do those cases require a tether to a particular request, or so here what we have is an allegation of kind of an ongoing or continuous violation based on the ongoing withholding of a letter. But I've been struggling to determine whether or not there also needs to be an allegation of a particular request.
Well, to state a Civil Rights Act claim, whether under federal or state law, but for our purposes, state law, you have to have a distinction being made on a protected basis. and the statute lays those out. And so to say I have been withheld, or a letter of recommendation was withheld, generally, that alone does not get you a cause of action under ACRA.
But there are other allegations of disparate treatment. I was treated differently from the men in the workplace. I had to do things they didn't have to do. I had to go to meetings they didn't have to. There's allegation of discrimination on the basis of national origin. They made fun of my name. They made fun of my accent. And then in the ACRA claim, it says, as described above, she was discriminated against by defendants on the basis of sex. Why isn't that enough to at least state a claim, whether it can be proven is a different issue, at least state a claim that the wrongful acts, including the alleged withholding of this letter, fall within an ACRA claim?
Yeah. Judge Kelly, I think you asked counsel for appellant to identify the facts that support. I heard him mention one, performance reviews. That is the only one that he mentioned that falls within the statutory time period, 180 days preceding the filing of the charge that relates. That allegation alone, performance reviews, one, we don't believe that's a sufficient adverse action for the case. I won't remember the name of it that was cited in our briefs. But also that fact, too, is not tethered to the basis of discrimination on sex, disability, or national origin. In fact, the allegations of the complaint, the detailed factual allegations of the complaint are laid out between paragraphs 132 and 169 that are within that time period. None of those allegations even mention national origin or disability, and only one hints at the different treatment on the basis of sex, and that's paragraph 150.
Well, the allegations that they made fun of her name, I think it can be inferred that that's an allegation of discrimination on the grounds of national origin, right?
It can be inferred. It's a weak thread. It's also something that occurred years before the filing of the charge. It's outside the 180-day time period.
So that specific act may not be actionable for lots of reasons, but it's also a fact that can be used to establish animus toward this particular person on grounds of national origin.
And I believe that allegation is limited to one of her coworkers, not a supervisor.
She complained and the boss didn't do anything about it.
Yeah. I don't think you can suddenly pull an allegation from years before the time charging period and make it, therefore we can resurrect the claim, because I'm now alleging that I filed a charge within 180 days.
Maybe the question is more, at least the one that I have is more, is discrimination as an actionable claim under ACRA a claim that is tied to specific instances as perhaps distinct from workplace harassment or hostile work environment claims, which are ongoing and subsume individual acts into sort of a continuum? Or is discrimination really, as Judge Kiley is kind of getting at here, discrimination, you can take these distinct acts and from them discern a discriminatory animus, and therefore all of the acts kind of come together to be the discrimination?
I can think of one scenario under the law where you can consolidate a pattern of events, and it's the Morgan case from the U.S. Supreme Court, which deals with harassment. A form of discrimination recognized by the courts, including under ACRA, but it's not alleged here. There's not an allegation of severe and pervasive conduct. There's, in fact, in the time period I cited, there is no allegation of harassment between October 4th, 2020 and the filing of the first charge in April 2021.
Is harassment typically pled as a separate claim for relief, or is it a part of a discrimination claim?
We're going outside the record, but I'll answer your question. I mean, in my experience, it's often pled as a separate claim, and you usually see the phrase hostile work environment or quid pro quo harassment to highlight And in particular, the Morgan case deals with harassment. In that case, it happened to be under race, but it's a hostile work environment. That's a severe and pervasive requirement. And I think that's missing from the complaint generally, but in particularly, it's missing from the 180-day period. And I believe it's the Peterson case from the Court of Appeals says you have to have an event that occurs within 180 days. It's not an arbitrary deadline.
Otherwise, it's not actionable.
Right.
But it can still be evidence to illuminate someone's state of mind.
Yeah, this court in Cruz, I can think of a scenario where you may be right, Judge Kiley, but there's the case that's not cited in the briefs, Cruz versus City of Tucson at 243 Arizona 69, 74, paragraph 20. The Court of Appeals in 2017 considered the issue of a 180-day period, in that case under a notice of claim statute. It's not an ACRA case, but said where there's no wrongful act that occurred within the statute of limitations, there, the 180-day period for the notice of claim, the claim's untimely. I think that's the answer to the question here.
I don't think it is, because the failure to provide a letter is not outside the 180-day deadline. It's not time barred, correct?
The failure to provide the letter is, I don't know that we know from the record when it was, I actually think it may have been after the filing of the charge. But if you assume that it was timely.
I think we can't assume that it's untimely. And that's the question on a Rule 12b-6 motion.
Fair enough. And so taking that, if the withholding of the letter of recommendation is untimely, then is it a sufficient adverse action to state a claim for sex discrimination? And we say no. And I think we're still missing the allegation that it's got to be tethered to some protected class.
Well, there are allegations, they did these bad things to me. They treated me differently from the way they treated the men. They treated me differently from the way that they, because of my accent and so forth. And later, they did bad things to me, including withholding the letter. Why doesn't that together survive Rule 12b-6 to say they were motivated by discriminatory motives, and they carried it out through these timely acts, and therefore that's enough to get you past the pleading stage?
So, running with that, Judge Kiley, which theory is it? It's not disability. You didn't file a charge until way too late for disability. Right. So that leaves national origin or sex. Under national origin, we have one allegation from years ago, nothing substantive, or it may have been a couple. I think it was not only the accent, the reference to calling her by a Hispanic sounding name, Julia. But you've got those two allegations that are way outside the time period. So I don't think it's national origin, and that leaves sex. And we just don't believe that there's a sufficient record in the verified complaint to support a claim for sex discrimination.
You said there's not a sufficient record, and I agree, but she doesn't have to present a record to survive a motion to dismiss. It's just, has she adequately stated alleged facts which, if true, could entitle her to relief?
We don't believe so. And the reason we don't believe so is the withholding of the letter of recommendation is, in itself is not a material adverse action. And I would also say it's not, again, it's a letter of recommendation to a graduate and professional school.
Well, counsel, your argument seems to be that the letter, that the denial of the letter stands alone. It's not, it doesn't attach to anything. It is your position that she wants that as a remedy, but a remedy for what is not clear.
Judge Howell, I think I mean, she wants it as a remedy. I think that was a reason she's seeking a declaratory judgment.
But it's not tied, your argument is it's not tied to any claim that's being made.
It's not tied. I'd also submit, and I believe we cited this in our brief too, that a letter of recommendation involves particularly for someone who is pursuing admission into school, involves some discretionary judgment at an academic level. And there are cases that are cited in the federal courts that courts ought not weigh in on whether professional opinions that are made in the course of assessment and being used on letters of recommendation. We press the same point on the publication credit as terms of, that's a discretionary judgment that Dr. Swanson was having to make.
To the extent that...
recommendation, though, the federal courts come out in different ways on whether a letter of recommendation can be considered an adverse employment action. Federal courts have reached different conclusions. Why is it appropriate for us to slam the door shut on a motion to dismiss instead of allowing for factual development and the presentation of the claim at the appropriate time?
Yeah. Judge Kiley, I have some reference. I don't believe they're cited in the briefs to the federal courts that you must be alluding to, but I think in all those cases, at least the ones I'm familiar with, they involve letters of recommendation for employment, not for admission to school.
And I just wanted to clarify, to the extent that the plaintiff identified as the motive for the withholding retaliation, is it appropriate for us to then also infer a discriminatory motive for the letter? She does that in her injunctive relief request.
I mean, I don't think so. I'm hearing two lines of thought with the question, Judge Perkins. Can you infer that there's a retaliation claim in the complaint? I don't think so.
I understand your argument there. There is no retaliation claim. I understand those are separately pled claims. A retaliation claim has different factors to be proven. But to the extent that what Judge Kiley is getting at is that the broadly pled facts and then the broadly pled ACRA claim kind of refers to this giant body of facts, and so we are we should infer that this particular fact rests on a discrimination claim, although the plaintiff herself has identified it as motivated by retaliatory animus and has not specifically identified it as motivated by discriminatory animus. Aren't we nonetheless at this pleading stage sort of required to make that inference?
I don't know that you're required to make that inference. You have to assume the facts that are pled in the complaint are true. But to suggest that the way the advocate has phrased the complaint and pled the case should be ignored in favor of looking at the context of the pleadings and a suggestion that perhaps it was discrimination when that's not what the complaint has pled, seems that may be going astray of where you need to go.
And are we stuck with the letter as written?
I don't see how any employer can be stuck with a letter that's written when there's an ongoing relationship. And, the suggestion that Judge Perkins made that certainly an employer has the right to reassess and reevaluate at any given time.
Thank you, Counsel. We appreciate your argument today.
Thank you.
Thank you.
Your Honor, the complaint, even though it was 25 pages long, is not perfect. And fortunately, under Arizona law, attorneys are not saddled with the burden of perfection. We can have especially under time constraints and everything, we can put together a complaint that the general aim of the complaint is to provide general notice to the defendants what the case is all about. So again, if we were talking about a negligence, if you just, instead of putting duty, breach, causation, damages, let's say you were in a hurry and you didn't put causation in there and pled exactly that, that's not exactly a ground for tossing out the entire complaint. Of course, this is an analogy, but just because a certain element isn't pled doesn't give rise to dismissing the entire complaint or that claim. And if it was just one element or just one fact missing or several facts missing, again, is there a overall basis for the complaint? And there are plenty of non-conclusory allegations in the complaint, meaning hard facts, not just listing of elements. The discrimination motive that counsel was talking about, yes, we can infer both discrimination and retaliation. They arise from the same general animus that the defendants had for my client, the plaintiff. And we should have the ability on behalf of the client to amend the complaint if there's anything that's not sufficiently illuminating to the defendants, but in general, that complaint, because of its length and all of its facts, apprises the defendants of exactly what Ms. Lorence is here and is requesting. So it's not based on whether this particular element was not listed or they would like to have another fact or another 5 facts or another 10 facts. It's the general body of the entire complaint and the relationship that it describes. There are plenty of...
Counsel, your time is up.
Oh, okay.
We appreciate your argument today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.
Thank you, Your Honor.